Hello, my name is Laura Richman. I'm counsel in Mayer Brown's Corporate and Securities Practice, and I'll be introducing you to the chapter in our recent cybersecurity publication that addresses Security and Exchange Commission guidance and enforcement regarding disclosure of cybersecurity risks and incidents. So my focus today is on the SEC's disclosure requirements and their ramifications. The SEC has not adopted new regulations specifically regarding cybersecurity disclosure in documents filed with the SEC. Rather, the SEC has clarified that various aspects of current rules apply to cybersecurity risks and incidents, and has provided guidance on how such provisions may require cybersecurity disclosure. Back in 2011, the staff of the SEC's Division of Corporation Finance issued CF Disclosure Guidance Topic Number 2 on cybersecurity. The staff, noting that digital dependence increased risks to reporting companies associated with cybersecurity, and provided guidance to assist public companies in assessing what, if any, disclosures should be made regarding cybersecurity matters in light of each company's specific facts and circumstances. The staff expressly prepared this guidance to be consistent with relevant disclosure considerations that arise in connection with any business risk. The staff's 2011 guidance remains in effect, but in February of 2018, the SEC published interpretive guidance regarding disclosures of cybersecurity risks and incidents, updating and expanding the staff's 2011 guidance. The SEC's 2018 guidance was adopted at the commissioner level rather than as another staff pronouncement, and this emphasized the SEC's vigorous commitment to cybersecurity disclosure. As you can see from this slide, the SEC believes that it is critical for public companies to take all required actions to inform investors about material cybersecurity risks and incidents in a timely fashion. In addition, the 2018 guidance explicitly addressed the importance of policies and procedures related to cybersecurity and focused on the application of insider trading prohibitions in the context of a cyber incident that has been yet to be publicly disclosed. In other words, the SEC is very concerned about insider trading when the insiders may know that a breach has occurred and the public does not. In a statement made contemporaneously with the Commission's 2018 guidance, SEC Chairman Jay Clayton expressed his expectation that such guidance will promote clearer and more robust disclosure by companies about cybersecurity risks. However, at the same time, Chairman Clayton advised that the SEC will consider whether any further guidance or rules are needed. So the basic framework for understanding and applying the SEC's cybersecurity requirements is that the SEC expects strong, understandable disclosure under the existing rules. And if that doesn't happen, the regulatory landscape could change. The SEC could decide to adopt new rules for cybersecurity if it considers them needed. The SEC's disclosure requirements impact various types of SEC filings, such as annual and quarterly reports under the Exchange Act and registration statements under the Securities Act or the Exchange Act. An overarching principle for determining what specific cybersecurity disclosure is required is materiality. And keep in mind that the materiality concept includes material omissions. As a result, discussing the possibility of future cyber incidents without mentioning that a significant data breach had already occurred could be viewed as misleading as a result of failure to state a material fact. The SEC's 2018 guidance expressly states that companies are not expected to publicly disclose specific technical information about their cybersecurity systems, the related networks and devices, or potential system vulnerabilities in such detail, because doing so could make these systems, networks, and devices more susceptible to a cybersecurity incident. However, the guidance also specifies that companies cannot delay disclosure solely due to ongoing internal or external investigations into cybersecurity incidents. Rather, companies may need to correct or refresh the initial disclosures made following an incident, in the SEC's words, including during the process of investigating a cybersecurity incident. As noted on this slide, there are quite a few specific requirements within the SEC's disclosure framework that could require cybersecurity disclosure. Because cybersecurity poses risks to so many companies, the risk factor requirements of the SEC's disclosure rules is a good place to start the discussion of public company responsibilities for cybersecurity disclosure. Among the issues that the SEC guidance suggests that companies should consider when evaluating their cybersecurity risk factor disclosures are the occurrence, severity, and frequency of prior incidents, and the probability and potential magnitude of cybersecurity incidents. Also consider the adequacy of preventative actions and the potential for reputational harm, and the impact of existing or pending cybersecurity laws and regulations, and the cost of cyber-related litigation, regulatory investigation, and remediation could also pose risks that should be disclosed in the risk factors. Management's discussion and analysis of financial condition and results of operations disclosure is an important SEC disclosure requirement that is intended to give investors the opportunity to see the company through the eyes of management, providing context for analyzing the company's financial information. So it is another requirement that can give rise to the need for cybersecurity disclosure. The SEC's guidance identifies the costs of ongoing cybersecurity efforts and the risks of potential cybersecurity incidents as items to be considered when preparing MD&A disclosure. These costs could include loss of intellectual property, the immediate costs of the incidents, costs of preventative measures, insurance, litigation, and regulatory investigation. The guidance specifies that the SEC expects companies to consider the impact of cybersecurity incidents on each reportable segment as well. If cybersecurity incidents or risks materially affect the company's products, services, relationships with customers or suppliers, or competitive conditions, appropriate disclosure could be needed in the description of the company's business. The SEC's rules also require disclosure of information related to material pending legal proceedings, which can also be relevant for cybersecurity to the extent there are any such material proceedings related to cybersecurity issues. And the SEC's guidance points out that cybersecurity incidents may affect financial statements. For example, financials could be impacted to the extent the incidents result in expenses related to investigation or breach notification, remediation, and litigation. Also, there could be loss of revenue, cost of customer incentives, or loss of a customer relationship. The incidents could give rise to warranty claims, the breach of contract, product recall or replacement, indemnification, and insurance premium increases. And there could be diminished cash flows, impairment of assets, recognition of liabilities, or increased financing costs. Proxy statements must disclose the board's role in risk oversight, and according to the SEC's guidance, this disclosure requirement should include a discussion of the board's role in overseeing the management of cybersecurity risks to the extent that such risks are material to a company's business. To quote the SEC guidance on this point, disclosures regarding a company's cybersecurity risk management program and how the board of directors engages with management on cybersecurity issues allow investors to assess how a board of directors is discharging its risk oversight responsibility in this increasingly important area. Although my focus today is on the SEC's disclosure rules, before I move on, I do want to mention that stock exchange have rules requiring their listed companies to quickly publicize any news or information which might reasonably be expected to materially affect the market for their securities. Therefore, a cyber incident could require a listed company to promptly issue a press release under their stock exchange requirements. In addition to disclosures, the SEC guidance covers policies and procedures. For example, the SEC expects companies to establish and maintain effective disclosure controls and procedures so that they will be in a position to make accurate and timely disclosure of material events. According to the SEC, companies should have controls and procedures that enable them, and again I quote the guidance, to identify cybersecurity risks and incidents, assess and analyze their impact on a company's business, evaluate the significance associated with such risks and incidents, provide for open communications between technical experts and disclosure advisors, and make timely disclosures regarding such risks and incidents. The SEC guidance specifies that a company's disclosure controls and procedures should not be limited to disclosure specifically required, but should also ensure timely collection and evaluation of information potentially subject to required disclosure or relevant to an assessment of the need to disclose developments and risks. The SEC's guidance expressly encourages companies to adopt comprehensive policies and procedures related to cybersecurity and to assess their compliance regularly, including sufficiency of their disclosure controls and procedures as they relate to cybersecurity disclosure. The SEC is clearly focused on cybersecurity breaches in the insider trading context. The guidance observes that cybersecurity incidents may constitute material non-public information and warns that directors, officers, and other insiders would violate the anti-fraud provisions of securities laws by trading in the company's securities while in possession of such material non-public information. The guidance encourages companies to consider how their codes of ethics and insider trading policies take into account and prevent trading on the basis of material non-public information, including information relating to cybersecurity risks and incidents. The SEC advised that it believes, and these are the SEC's words, that companies would be well served by considering how to avoid the appearance of improper trading during the period following an incident and prior to the dissemination of disclosure. The guidance also reflects the SEC's concern regarding selective disclosure of material non-public information relating to cybersecurity. It specifies that the SEC expects companies to have policies and procedures to ensure that any disclosures of material non-public information related to cybersecurity risks and incidents are not made selectively, and that any Regulation FD, and that stands for fair disclosure, that any Regulation FD requirements for public disclosure are made simultaneously in the case of an intentional disclosure as defined in the rule, or promptly in the case of non-intentional disclosure and is otherwise compliant with the requirements of that regulation. There are a number of ramifications for deficient cybersecurity disclosure. The CEO and CFO must certify as to the accuracy and completeness of annual and quarterly reports on Form 10K and 10Q filings and Form 20 and 40F filings for foreign private issuers. According to the SEC's cybersecurity guidance, when the CEO and CFO make their required certifications regarding the design and effectiveness of disclosure controls and procedures, they should take into account the adequacy of controls and procedures for identifying cybersecurity risks and incidents and for assessing and analyzing their impact. CEO and CFO certifications can become the subject of SEC enforcement procedures. That is true generally and also in the cybersecurity context. The SEC staff can and does make comments on cybersecurity disclosures when reviewing public filings. For example, they may ask for clarification as to whether a company has experienced any cyber attacks or other security breaches. The SEC may require additional disclosures. Hopefully that'll be in future filings, but the staff could require amendments. After the comment process is completed, both the SEC's comments and the company's replies will become public. Also remember that if the SEC generally becomes dissatisfied with company cybersecurity disclosures, we could see in the future additional SEC regulations. Ultimately, the SEC may bring an enforcement proceeding against a company for insufficient cybersecurity disclosure. As many people are aware, earlier this year, Yahoo, now called Alibaba, settled an SEC enforcement action for an agreed-upon $35 million penalty. The settlement arose out of a massive breach of Yahoo's user database. The breach occurred in December of 2014, but was not disclosed for almost 2 years. And according to the SEC's orders, Yahoo risk factors were materially misleading because only future data breaches were discussed, without any mention of actual data theft. The SEC also considered Yahoo's MD&A misleading because it didn't discuss known trends or uncertainties resulting from the cyber incident. The SEC also concluded that there were disclosure violations arising from a proposed sale of its business based on representations contained in an agreement that was filed with the SEC denying the existence of any significant data breaches. You may have read in the news that the SEC recently brought an enforcement action under the Identity Theft Red Flag rule for the first time, and the issues raised by that statute are different than the disclosure rules that I'm talking about today, so they're outside the scope of this webinar. However, I do want to point out that the enforcement proceeding reflects an SEC decision to take action relating to cybersecurity, and therefore it is another indication that cybersecurity is at the forefront of the SEC's attention. I want to end today's talk with a few practical considerations. By issuing cybersecurity interpretive guidance that was approved at the full commission level, the SEC emphasized the importance it is placing on cybersecurity disclosures and policies. The 2018 guidance serves as a reminder that disclosures and policies in this area should be evaluated regularly. And I think management, senior management, lawyers, accountants should all be involved in this process. And I also think it's important to have input from IT personnel. That can be very helpful. Companies should review, update, and evaluate all disclosure requirements that could trigger a need to discuss cybersecurity and cyber incidents. And this is a particularly important time of year to focus on these disclosures. Not only are quarterly reports due soon for calendar year companies, but many companies begin preparations for their annual reports in the fourth quarter. It is good to build in time to review cybersecurity disclosures, especially to the extent that any disclosure is new or updated. You should, of course, pay particular attention to the disclosure rules called out by the guidance, but also consider whether there are other areas in SEC documents where cybersecurity discussions can be appropriate. For example, some companies choose to highlight cybersecurity experience as director qualifications where applicable. And some companies choose to discuss management reporting structure or the frequencies of reports relating to cybersecurity. Cybersecurity is sometimes discussed as a strategic focus or as a subject of shareholder engagement. Companies may also want to disclose mitigation efforts, including hiring, training, establishment of systems and procedures, and contingency planning. It's also very important to remember that the guidance encompasses more than disclosure. Companies should periodically assess whether their existing disclosure controls and procedures are adequate to assure timely disclosure of cybersecurity risks and incidents, taking into account each of the various SEC requirements that could trigger cybersecurity disclosure. Another practical step companies can take with respect to cybersecurity is to have their board of directors evaluate whether they are sufficiently involved in the oversight of cybersecurity risks and whether they need additional training in this area. Boards should determine the extent of board committee involvement in oversight or cybersecurity risk and the appropriate committee or committees to consider these issues. The Nominations and Corporate Governance Committee may want to assess whether the current composition of the board has sufficient expertise relevant to cybersecurity. And companies preparing proxy statements should consider discussing board oversight of cybersecurity risk expressly as part of their discussion of the board's role in risk oversight of the company, both in light of the SEC's guidance and also to emphasize to investors, customers, and other stakeholders how seriously the company takes cybersecurity. Companies should also consider whether to revise their insider trading policies and procedures to expressly prohibit trading in company securities while in possession of non-public information regarding cybersecurity incidents. The SEC's guidance emphasizes the importance of well-designed policies and procedures to prevent trading on the basis of all types of material non-public information, including information related to cybersecurity risks and incidents. The SEC observed that insider trading policies and procedures that include prophylactic measures can protect against insider trading in company securities before disclosure of a material cybersecurity incident. As I noted a few minutes ago, the SEC concluded its discussion of this point by saying that companies would be well served by taking steps to avoid the appearance of improper trading in the period following a cyber incident and public disclosure of that event. While the SEC's recent guidance does not mandate changes to insider trading policies, the well-served language used is blunt enough to be a strong hint that it's worthwhile for companies to consider some type of policing action to lessen the possibility of insider trades in company securities at a time when there is an undisclosed cybersecurity breach. Such action could include amendment to the insider trading policies, enhanced insider trading education programs, and or strict enforcement of pre-clearance proceedings and procedures. Following a cybersecurity incident, companies may want to consider whether it would be prudent to prohibit trading by corporate insiders by imposing a special blackout period to last until the breach is made public. Also, insiders possessing material non-public information of any type, including a cybersecurity breach, shouldn't enter into a Rule 10b5-1 trading plan while they have such non-public information. And also, insiders that have pre-existing 10b5-1 trading plans should consider the optics of having trades occur pursuant to a trading plan in light of undisclosed material non-public information. Public companies need to recognize that if a cybersecurity incident occurs, consideration of required public disclosure plays an important part of their incident response process. Companies may need to balance cooperation with law enforcement with the need for public disclosure, recognizing that the SEC's guidance specifies that an ongoing internal or external investigation into an incident does not itself justify a delay in public disclosure. For example, companies should consider in advance how to manage differences in disclosure obligations under state data breach laws that may allow a company to refrain from notifying consumers of an incident at the request of law enforcement, or while an investigation of the scope of the breach is ongoing, with the SEC's obligations to disclose in a manner that minimizes legal risk and reputational harm. And companies should also bear in mind that a new incident may require them to revisit disclosures they previously made to investors. I hope you found this talk helpful. I know I just presented a lot of details about SEC concerns on cybersecurity in a short amount of time. I'll close by suggesting that you may find the corresponding chapter of our new cybersecurity publication to be a useful reference. Thank you for listening.